Thank you, Chair. Good morning, Mr. Dwyer and Mr. Forsyth. Thank you so much for the evidence you've provided so far. Just on the wage theft, the underpayment of super as wage theft, you have noted, and obviously in the previous question to Senator Barbara Pocock, but also there's been many submissions that say that ATO estimated $6.2 billion of super not paid in 2022 to 23. And we have seen that to be a substantial rise from the $3.7 billion estimated to have been stolen from workers in 2017 and 18. You were sort of briefly saying what can be done about it, but why would you say, why is super theft on the rise, and what can be done through perhaps this piece of legislation about addressing underpayment of super?
Thank you, Senator. I guess to put it simply, the Australian Taxation Office, we'd say, isn't set up necessarily or adequately to be a proper enforcer of unpaid wages, which is what super is. Their processes seem to enable great lengths of time to pass before someone might get some feedback. We've had examples of members raising unpaid super with the ATO. This is prior to them being members. Those matters, and then getting letters. But the first acknowledgement of it can be sometimes several months from the time that you raise it, and then in an inordinate amount of time before any sort of action seems to take place. And super, all of this unpaid super over several years means the money hasn't been in my account and hasn't been accruing interest and compound interest. So therefore, my retirement savings have suffered during that prolonged period of time. Anyway, our proposition is simple. Super is wages, and the enforcement of unpaid wages should be in the industrial system. And within this industrial system, we should all be turning our minds to making the enforcement and recovery of wages simpler, more timely, and less costly.
Thank you. And I note that SDA submitted that wage theft continues to occur on large and entrenched scale, and that criminalisation has not yet led to a material reduction in underpayments. Now, both the SDA and NTEU also submitted that unions should be empowered to investigate wage theft matters, with the NTEU going further to suggest unions should be able to refer potential offences under the Section 327A to the AFP and CDPP. Now, taking both the submissions together, is it merely a matter of time before the offence has a deterrent effect, or would you say that there are other structural changes that are necessary? And to what extent would expanded union investigation and referral powers might be part of the answer, especially when it comes to putting it into practice and given the high standard of proof required under Section 327. And Mr. Forsyth, you can also jump in if you'd like.
Thank you, Senator. I might just deal then with as you said, I mean, it is still, to us in legislative terms, it is early days, or still early days, with regards to the Section 327 provisions, but would like to think that if we can get the foundation correct, we would actually then, I think that would provide some assistance in terms of focusing in on those very serious, systematic underpayments, but we'd also like to think that some of the threshold questions, or those thresholds, are lowered to make it, I think, easier to succeed in such a prosecution. But the structural changes that you ask about, I just come back to, we need to have laws that allow the registered organisation in each sector to give them the powers to go in and be part of the solution of cleaning up wage theft. We need to have the powers. Those unions are in those workplaces regularly. We have in workplaces nearby, so it's quite efficient to be able to go across and conduct a spot check, particularly in communities where conversations will often point to, we know so-and-so is underpaying. The current laws, though, unless we've got a name from a person and they're imprimatur to proceed with that, they feel exposed, they don't want it, and therefore all we can do is refer it to the Fair Work Ombudsman, or it doesn't get attended to. And I think that's an unsatisfactory outcome. So we need to have an expansion of the powers that industry unions have to enforce wages in their sector.
Yeah, thank you.
Yeah, I'd probably add to that in our view, it would be unrealistic to expect that the introduction of the criminal wage theft offence would already have led to a reduction in the incidence of wage theft. We need to see how it operates over a longer time frame, I think. But what we won't accept is that this means there was never a problem to be dealt with in the beginning. The evidence is just so clear from the countless inquiries that have been conducted over the last 11 and 12 years at federal and state level, just how widespread and systemic this problem is. In terms of the role for unions, in addition to what the SDA has put forward, as we've said, we think there is a role for a registered union in being able to help a person who thinks they've been ripped off in terms of their wages find out how much they ought to have been paid, do that laborious work, help them do that work of calculating what the underpayment should be, and then seek redress for it through an accessible process that doesn't take months in the federal court system. And that's why we think being able to utilise the powers of the Fair Work Commission to help workers get that evidence together, work out what the appropriate amount of the claim is, and then have that body help conciliate the claim. At the moment, we have a model where it's the Fair Work Ombudsman that essentially provides workers with resources to help themselves in terms of working out what, if they've been underpaid and if so, by how much, and then has what's called an assisted voluntary resolution process where they try and get the parties to reach an outcome. We think a better process could be utilised in the Fair Work Commission.
Thank you. And just quickly, I'll refer to the Victorian Trades.
We really need to finish up here, Senator Payman. Yeah, thank you.
Okay, I'll put the rest of the questions on notice, but just on the submission by the Victorian Trades Hall Council, when Victoria criminalised wage theft, the task of investigating was given to a new body, the Workforce Inspectorate Victoria. Now, to what extent do you agree that with the Victorian Trades Hall Council's view that the Fair Work Ombudsman has a history of taking a light touch approach to enforcement?
Well, there are instances where we could see perhaps the Ombudsman may have taken a tougher line. I think back to the George Calumbaris wage scandal in his restaurants in around 2019, where what the Ombudsman did was to enter into an enforceable undertaking under which a contrition payment, from memory it was around $200,000, had to be paid, an admission of liability and the introduction of measures within that organisation, such as training of managers, better compliance systems, better payroll systems was required. There have been other similar examples of that over the years. And that's where I think perhaps from the union point of view, there has been a view that in certain cases the Ombudsman hasn't gone in hard enough in relation to wage theft. But certainly now with the existence of the criminal offence, there is plenty of opportunity for the Ombudsman to prove those criticisms wrong.
Anything you'd like to add, Mr. Dwyer?
No, Senator. I'm not particularly familiar with the Victorian jurisdiction and the laws you talk of.
Okay, no worries at all. Thank you, Chair. I'll put the rest of the questions on notice.